Can a power of attorney be used to close a real estate transaction? Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's question. Yes, the answer is yes. A power of attorney can be used to conduct a real estate closing. It is, so this week, we're January 2021. This week I did attend a closing where I represented an individual that was the buyer of real property. We all had masks on. My client had to sign mortgage documents with a mask. I had a mask. The bank attorney was present. You know, a New York closing is sort of like a wedding. Everyone's there. Full attendance. Bank attorney. And we closed at the office of the bank attorney. A title closer. Seller's attorney. Sellers. Buyer. And in this transaction, I was the buyer's attorney. Now, the sellers were three individuals, siblings, all of an older age, three siblings. One of the siblings was at home, unwell, just a little bit sick, older, infirm. And this individual gave a power of attorney to his sibling to conduct the closing. So a power of attorney can be used. It's sort of difficult to use a power of attorney to enter into the mortgage. Not impossible. I've seen it done with prior approval. But the bank doesn't really want, my experience is the bank doesn't really want a person to be obligated to a mortgage through a power of attorney. There might be a specific reason. Person is working, maybe they're a first responder, maybe they have a job where they can't get off on that given day. Maybe they're out of state for an extended period of time. So it's not as frequently used for a buyer. It is more frequently used to conduct a closing with a power of attorney for a seller. Now, we take steps to make sure that the power of attorney is in full force and effect. The title closer, we all observed the power of attorney, made sure that it was validly executed. That power of attorney will also have to be recorded along with the deed. The person that was using it had to sign an affidavit. It's a sworn statement indicating that it was in full force and effect, that she had no knowledge that it had been canceled, that it was a legitimate document, and that this is the agent, and that the principal of the power of attorney was still alive. And what was done to further ensure that is that the title closer telephoned the location where the principal was and had a brief conversation with him. The seller's attorney got on the phone first, verified that that was his client, and then the title closer did in fact speak to this individual and said, asked a few questions to make sure that it was A-OK. And that's how you use a power of attorney in a real estate transaction. I sort of commented at the closing that the power of attorney should speak for itself. Now, I was fine because it protected the interest of my client to make sure that the title closer spoke to the person. However, as an attorney that prepares powers of attorney, I do feel that that undermines the document in and of itself. So that's probably a conversation for a later day. Really, if you had to demonstrate every time that the person is, well, it's the law, the person has to be alive, right? The power of attorney loses its effect if the person has passed. But what if that person was in a coma and had signed the document, right? I don't want to go down a rabbit hole of this discussion at this point. if you have a power of attorney and you want to speak to me about it. If you need to use a power of attorney to close, let me know. I will assist you. We can definitely do that. FrankBrunoLaw.com. Be well, stay safe and healthy.